Again, I'm not a lawyer. Neither is the land agent that's coming to you, knocking on your door, saying, I'm going to promise you all these things, and here's the agreement, sign here. They're not an attorney either. In fact, they can't even officially, legally speak for the energy companies. What they say, frankly, doesn't matter. What matters is what's in the agreement. Their interest is in getting signatures because that's how they get paid. The agreements expressly state, and again, these are agreements that I've read. I don't know what agreements they're handing you today, but the agreements expressly state that the agreement contains the controlling terms, and any oral agreement or other written agreements not expressly part of this agreement is superseded, null, and void. So it's only what's on that paper that's count. So if they told you one thing and you can't see it in plain English, demand it be put in plain English. Otherwise, it ain't gonna be there. The agreements often state that the grant that you're granting them is for the sole authority of any and all activities related to collecting, converting, and transmitting energy into electrical energy on the property. So in other words, if it deals with wind energy and the transmission of wind energy, it's their call. They can do anything they want, wherever and whenever they want, according to the terms of those easements. You also forfeit any rights or compensation that are not explicitly stated in the agreement for any effects of the agreement. Noise, shadow, electrical interference, property damage, or, quote, other effects, and that's a quote from the agreements, that is attributable to the work on the turbines. You also waive enforcement of any local, state, or federal regulation related to wind development on your property, according to some of these agreements. You need to be careful of these terms. As I said, you need to get a good lawyer to go over this stuff for you. These agreements also typically run with the land regardless of ownership, sometimes for as long as 50 years. I can't tell you the number of people that we heard from that were just beside themselves trying to figure out ways that they could get around things in the agreement because their parents or their grandparents had sold the wind easements to the energy company, and the energy company says, we're going to come in and do X, Y, Z. And they're saying, but I built my house over here. I don't want that there. That's too bad. Those rights were given up as a part of the agreement, and those rights run with the land. It states that each party has had the benefit of review by legal representation. It states that in the agreement because if you go to court later and say, well, I didn't really understand what this term meant, the court's going to say, that's too bad. It says here you have the opportunity for a lawyer to look at that stuff on your behalf. If you failed to do so, that's on you. That's why that statement is there. So get a lawyer that's good at that stuff because you're screwed after the fact. Any legal issues regarding the land or its use as a result of wind power facilities will be controlled by them according to the agreement. You may not plant trees or erect anything that they deem may interfere with their activities or the wind. So now you got to ask their permission. If they've got wind turbines on your property, you can't do anything if they say that might impact the wind that's going through those turbines. It effectively cuts out any tenant farmers for saying anything. Are there any tenant farmers in here? Any landowners that lease land to tenants? A few of them. Your tenants effectively don't have a say in this stuff now, according to many of these agreements. Now, all of these agreements and all of these terms that I'm going through, those are subject to your negotiation. Do it through legal counsel. And if you're concerned about your tenants, make sure you involve them and have that injected in the agreement as well. Otherwise, They're cut out. They have no say on anything. The terms often say that except for a few exceptions that are favorable to them, you can't initiate any action to terminate or cancel the agreement after the fact. Just says right there, once you sign it, you're done. You can't challenge it. And they don't have to inform you of anything after you've signed it, even if they sell the rights to another developer. That's their right. They can sell it, do whatever they want. They don't have to tell you squat. This next one is kind of a big one. It's related to a legal doctrine called rules of construction. Rules of construction essentially say that if there's an arbitrary clause, if I write this agreement, right? I write this agreement, and I'm going to give this agreement to Candace. And we sign it. We both agree to it. Later on, we find there's a clause in here that's kind of ambiguous. And depending on how it's interpreted, it can either go in my favor or it could go in her favor. Alternatively, disfavor me or disfavor her, right? That legal doctrine of rules of construction says if I wrote it and there's an ambiguous clause in here that could be interpreted one way or the other, the court has to interpret it to my disfavor. In other words, it's to her favor. The theory being, I wrote it, I should have known about it. And if I wrote it ambiguous, I was probably doing it to be tricky. That's why that doctrine exists. Some of these agreements have a clause that explicitly state that this doctrine of rules of construction is expressly waived and shall not be employed with regard to this agreement. Isn't that something?
Wow.
A doctrine that's there to protect people with these agreements, and they write that doctrine out as a part of the agreement. You also waive the right to a trial by jury and any rights to be part of a class action that's based on any litigation in connection with the agreements. And finally, you agree to indemnify and hold them harmless as a result of a very wide range of things, too many for me to put on the slide, that is effectively anything they can think of, you're agreeing to indemnify and hold them harmless from all of these things. Again, those are clauses that were in easement agreements that I read a couple of years ago. I don't know if they're in easement agreements that are being looked at today or not. The lesson here, what I'm trying to emphasize by going through these things, is there's a lot of stuff in those agreements that you may or may not agree to. You really need to get an attorney to look at those agreements for you before you sign them. With that, I am done with my slides. What questions do you have? Yes?
So when you sign one of these contracts, it doesn't apply just, does it or does it not apply just to the spot where that windmill sits on my land, or is it more than that?
Typically, and again, devil is in the details, right? You have to look at the individual agreement. But typically, these agreements are for parcels of land. So it may describe 40, 60, 180, 240 acres. Whatever land is encompassed under that agreement, you're giving them carte blanche to do what they want on that 240 acres, wherever they want.